Okay, our next case is Synergy Equipment versus Reese, number 2024-0139.
May it please the court. My name is Michael Orr, and along with Megan Comunale, we represent the petitioner Synergy, who asks that this court reverse a portion of a final judgment entered in accordance with the jury verdict, awarding $50,000 for emotional distress damages in a tortious interference with a contract or tortious interference with an advantageous business relationship case. We have reserved 5 minutes for rebuttal. The issue that is before the court today begins with whether or not the impact rule applies to intentional torts. That is the first certified question that the 6th District certified to this court.
Michael, I'm sorry, can I ask you a question?
Yes, Your Honor.
Before you go into your arguments, I want to ask you a threshold question. You're in the minority of states that still have the impact, right?
Yes, Your Honor.
Is this case the correct vehicle to get rid of the impact rule altogether?
I would submit to the court that looking at other states is problematic, and I know we detailed Texas, for example, in our briefing, because the FJA in their amicus brief suggested that Texas is one of those states that had abolished the impact doctrine and said we should perhaps do the same thing here, but then we don't consider the fact that in Texas, a tortious interference with an advantageous business relationship case doesn't carry with it the ability to recover emotional distress damages. That's part of the problem in looking at other states on this issue, because they have a whole different body of law, a whole different body of statutes that might apply to the various claims that are at issue. Certainly, justices have written opinions in the past about their position on whether this rule should be abolished or not. In Gracie versus Eaker, in Roel versus Holt, in Abril, Justice Pariente wrote a number of opinions suggesting that the rule should be abolished. Justice Cantero, in the Abril opinion, wrote about all the issues with the application of this rule.
Talk to me about the dissent in Willis, and you know, why shouldn't we adopt that approach? Justice Cantero outlined tell me about it, and why shouldn't we go with that?
I would submit that is not the approach that this court should take, and here's my reason why, Justice Francis. The initial underpinning of this rule from International Ocean versus Saunders, it was all about the need for a competent standard of proof, so that when plaintiffs came into the courts in the state of Florida, they had some basis to provide the jury with which to calculate or measure damages for emotional distress. And so in Saunders, when you have someone who lost his wife, was not able to be with her at the hospital, was not able to be with her at her funeral, and then had a jury award emotional distress damages for what most people would say were probably very real emotional distress damages, the Florida Supreme Court said, we're not going to permit those claims for want of competent proof. And so while I agree with Justice Cantero in the sense that the rule has been eroded with exceptions, it's been eroded with each time a case comes before this court on some new claim, like in Abril having a claim that someone breached the confidentiality required under a statute for HIV diagnoses, that the court can come back and say, well, those claims carry with them predominantly emotional damages. And in some opinions, the courts say only emotional damages.
But you just don't think that this is a case where we finally put the nail in the coffin?
I don't, Your Honor. I think
you'd lose if we did that.
What's that, Your Honor?
You'd lose if we did that.
Most certainly, Judge. But I think the people in the state of Florida, the judges and the litigants before the courts, win if this court reaffirms the rule as originally stated.
Can I follow up on what Justice Francis asked?
Yes.
Are there any, to your knowledge, any states who still retain the rule that use it for intentional torts? Or is it only in the negligence category?
My review of the law, Justice Grosshands, and this is detailed in one of the amicus briefs, is there are only a few states that still use it. But just as in Florida, there haven't been cases where courts are considering an intentional tort, which of course is why we're here, because we finally have one of those causes of action where a court...
Would you agree that if we applied it to the intentional tort, that we would be perhaps the only state that has done so?
We may be one of the only states that has been presented with the issue at the Supreme Court level.
Well, and if we did it in this case, this would be, tell me if I'm wrong, the first case in which our court has actually held that the impact rule is applicable to a cause of action for an intentional tort.
I would say...
Now, we've said a lot of things, but I'm talking about actual holding.
Yes. I would say yes and no. Yes, in the sense that there hasn't been an intentional tort cause of action that's gone up to the court, and the court has actually ruled that this intentional tort cause of action is applicable, or the impact rule is applicable to it. However, the very rule adopting the very case adopting this rule, International Ocean versus Saunders, the court did not use the word negligence. It said torts.
But it was a negligence case. It was actually a contract
case.
Contract but case. It was a negligent performance of a contract, I suppose,
sure,
which
right.
There's other problems with that. But there we get into other issues. But let me ask you this also. Let me ask you about Scott versus...
Scott 1 or 2?
Our Scott.
Yes.
2, I guess it would be 2.
Yes.
The 1990 Scott. And I realize we have said all kind of things. And I mean, I compliment both sides on your briefs. You've tried to work your way through all of that, and in a way that brings some coherence to what we've done. But I look at Scott, and I realize you kind of dismiss Scott. I would too, if I in your position. But I think it's a little hard to dismiss. And again, how it fits in with other things, I mean, it's kind of one of these things that's bobbing around out there. But when I look at Scott, and I realize the term impact rule is not used there, but it's certainly about emotional distress damages. That's what the certified question was about. It's about the availability. The certified question was, are damages for emotional distress available to a plaintiff in a wrongful discharge action under this particular section related to, as I recall, workers' comp claims? So that's what's at issue there. And then when we answer that question in the affirmative, they are available. But our reasoning is not expansive. I will grant that. But it does seem to undermine your position, because it says we hold that an employer who violates the statute has committed an intentional tort, thereby exposing itself to liability for damages for emotional distress. So we basically say, the only way I can read that is at least this, when the court was looking at it here, over the dissent of Justice McDonald, pretty strong dissent. When we were looking at it here, we're saying if there's an intentional tort, there are damages for, at least the potential for damages for emotional distress. What am I missing about that?
I think that's a fair read of the case, Your Honor. Justice Kennedy, I would also say it's a statutory cause of action that the court was analyzing. They weren't addressing the impact rule. We've addressed the other issues with the case. But certainly if we're going to argue over whether or not intentional torts are going to have the impact rule applied, that should be the analysis the court's undertaking, and it didn't take in that case. And part of the problem with this case is evidenced by the 6 DCA's majority opinion. They're just looking at all these opinions and taking inferential leaps and inferences and reasonable possibilities from opinions when we don't have an opinion squarely addressing it. And
if we were going to do our job, we'd be showing our work. So what do you think the answer is? Is this an extension of precedent that, we're kind of reading this tort reference in our previous cases really literally and kind of applying it as we would a statute? Are we looking for a principle that applies equally in tort, that implies an intentional tort, kind of like a common law principle that we're extending? Or is it kind of this policy idea that's floated around Supreme Court jurisprudence in the common law context?
That's a great question, Justice Sasso. And from our vantage point, it's really going back to the original view of the court from Saunders, where it applies across the board to torts. And we're talking about torts in general. So in the sense that if somebody had a trespass claim and a neighbor went on to another neighbor's property and stomped on their rose bushes, they would have a cause of action to get the pecuniary loss for the cost of the rose bushes. But they couldn't sue their neighbor and say, I was really upset, I was embarrassed, and I lost sleep, and by the way, give me $50,000. There has to be some competent proof. And I think if the court goes back to the original intent of the impact rule and sets forth that, one, it applies to intentional torts, it applies to all torts. And two, yes, Justice Kerr.
What I was going to say is that the trouble with that is you're certainly right that the logic behind the impact rule applies to any kind of tort, right? The central logic is that it's hard to value emotional wrong. It's hard to value emotional loss, harder at least than pecuniary. So whether I suffer such a loss because of your negligence or your intentional tort, the policy justification for the impact rule is the same. And yet, it is always associated with negligence. The restatement at Section 47 definitively links it to negligence. Our cases, by and large, I mean, you make the point that the word negligence doesn't appear in international ocean. However, there's no allegation that anyone purposefully delayed that telegram. It's clearly it's one of these weird situations where the doctrine grew up in negligence and its logic has been articulated in negligence, and yet the logic applies to intentional torts as well. No one's ever taken it there.
I would say yes and no that it grew out of negligence, because in the Saunders case, when the court was analyzing courts' opinions from other states, the court looked at intentional tort cases. They looked at seduction cases. They looked at deceit cases. They looked at other intentional tort cases where the impact rule had been applied. So this is a function of the cases that this court has considered have been negligence cases and statutory cases. I mean, a lot of these cases are where someone's claiming that, they breached a confidentiality under a statute, or they had some other legal malpractice claim. And so, generally speaking, those are the causes of action that have made it here. But then you have cases like LRX from the 4th DCA in 2005, where the court essentially said you don't get emotional distress damages in a tortious interference case. So perhaps that's why this court hasn't had to deal with the issue.
So what's the rule that you're asking us to do?
The rule that I'm asking for, Your Honors, in writing the opinion. First, I would start with the first certified question in writing the opinion. Does the impact rule apply to intentional torts? The answer is yes. The second certified question, I'd actually use Judge Smith's.
All intentional torts.
Yes, Your Honor. In the second certified question, I'd use the certified question from Judge Smith in his dissent in the 6th DCA and say that it also applies to a claim of tortious interference with an advantageous business relationship or contract. And the rule should be, in the state of Florida, the impact rule applies such that you don't recover as a plaintiff for emotional distress or mental anguish damages unless you have competent, substantial proof. And I would submit this court has the ability now to say that needs to be expert witness testimony from a medical expert.
So you're saying competent, substantial proof of
the emotional distress damages, yes. And the Kentucky case that was cited in the amicus brief by FJ talks a little bit about that evidentiary standard, and that would perhaps cure some of the problems with these cases where somebody just comes into the courtroom without any before and after witness, without any documentary proof of their damages, without any expert testimony, and says, I had a rough day, I had problems sleeping, I was embarrassed, I want some money from you, the jury. The only exception should be punitive damages cases, in cases in which this court has already recognized an exception. And for those reasons, we ask that this court reverse.
Good morning. We'd like to allocate 10 minutes of our time to the Florida Justice Association for their arguments on behalf of the respondent in this case. Good morning, and may it please the court. My name is Scott Adams, along with my co-counsel Ryan Labar and Kyle Mason of the Florida Justice Association. We're here on behalf of the respondent in this appeal in which the petitioner seeks to nullify a jury's verdict for its intentional and unjustified interference with Mr. Reese's employment, in which the jury awarded mental anguish damages. They seek to do that by invoking the impact rule. They made that argument to the learned trial judge, and he rejected it. They also made that argument at the 6th District Court of Appeal, and they likewise rejected it. And we're sure after here today that this court will reject it. This is because for the last 40 years, this court has precisely and succinctly stated the impact rule is before a plaintiff can recover mental anguish damages due to the negligence of another, they must prove a physical impact.
Do you agree, though, that we haven't squarely addressed this issue in the context of intentional torts, though, or do you think this is just a following precedent issue?
Our position would be, Your Honor, that the rule is, as been described, negligent. Therefore, because it's negligence, which is a reasonable, prudent person standard, that intentional torts are outside it by definition when it makes that statement. And we believe that it's clear because in 1950, this court made clear in Kirksey versus Jernigan that you could not recover psychic damages, a plaintiff could not recover psychic damages for simple negligence. It used the term simple negligence in that case. And the reason that's important is 8 years after the Kirksey decision, in the Slocum decision, this court stated that apparently Kirksey allows for mental anguish damages in intentional torts and in malicious torts. In fact, 6 years after that ruling in 1964, in LaPorte, it drew a distinction between negligence cases and those cases that are intentional and malicious, saying that basically the impact rule applies to negligent cases, not intentional tort cases.
So if the purpose of the impact rule is a proof issue, essentially, for better or worse, Florida common law for quite some time has adopted this rule of logic that because these damages are so hard to prove that in the context of negligence claims, you're not going to get emotional damages absent some impact. That rule of logic seems to apply equally across torts, including intentional torts. Why would it not apply equally in the context of intentional torts?
First, I would say, Your Honor, in this case, the quality of the evidence was never attacked at trial. The quantity of the evidence was never attacked at trial. The only issue at trial was, regardless of that, the impact rule would prevent the plaintiff in this case from recovering mental anguish damages. Now, as far as the application to intentional torts, we would disagree with the interpretation of the Saunders decision.
I'm not talking about any decision in particular. I'm just saying as a matter of logic. Why is there any difference between tort and intentional torts and applying a rule that's targeted at a standard of proof?
Sure. The logic seems to be, from the case law and just from legal precedent, that the fact that there's a higher degree of culpability in the determination of intentional torts, similar to the statutory claims such as 44205, where you see where mental anguish damages are awardable under other statutory causes of action. When there's this higher degree of culpability, the law will allow a determination of those mental anguish damages at that point.
So wouldn't that rule go more to categorically what damages are available versus matter of proof? I could see how, an intentional tort you want to, because this isn't just like an assignment of rights and responsibilities because of accidents, essentially, this is an intentional action, that there's a broader category of damages available. But I don't see how that would differentiate the logic that this one category of damages we've said is spiritual in nature, such that like we can't assess it unless there's something really palpable to give rise to the damages. And so I'm just not seeing how that would be any different in the context of intentional torts.
The proof would be, our position would be the proof would be the same in cases such as a physical impact. They say there's a physical impact, therefore you get mental anguish damages. The proof is still the same under that scenario as well. It still soars in the spiritual realm in a negligence case with an impact. It's the same with intentional tort. The reason that it gives it some credibility, and it seems that the courts are drawing a distinction. This court has consistently drawn a distinction when there's an impact, right, under Saunders, and lists the 3 opportunities for recovery as it synthesizes the cases. And our position would be the Saunders decision does recognize intentional torts as recoverable. And we would say that because if you read closely the analysis in that case, what the court does is it says the Texas rule, which allows it in any case, it then attacks that and attacks those cases. And then it lists 3 cases, 2 from England and 1 from the Supreme Court of Michigan, the Tribune Company versus MacArthur case. And it even quotes the language there. It says an intentional act, or not an intentional act, a voluntary act, and an act of very gross neglect. And if you look at the underlying opinion in that case, it says mental anguish damages are recoverable for a voluntary act and for a very gross neglect situation. So from the foundation of this court's precedent, the common law has always been that if there's an intentional tort, you get mental anguish damages. That was revealed in the...
Could I ask you, is it your position that just sort of everything is available? Like if there's no victim impact rule of application to intentional torts, and they're going to argue mental anguish, that it's sort of everything is on the table, they can argue whatever they want in any type of case? Or do you think there should be any parameters? Should there be a foreseeability factor? Should there be reasonableness? Should there be any sort of those types? Should there be expert testimony required? Is there any guardrails, or is it just anything can go to the jury?
Sure, Your Honor.
Not foreseeable, not anything.
It would be the basic tort principles of foreseeability would be applicable.
So you would think all of those same principles still apply?
Yes, Your Honor. Yes, that would be applied. Now, to be clear, our position is not advocating for the jettison of the impact rule, as this court has stated, while it's well within its rights to do that. All we're simply saying is that the impact rule, as stated by this court, applies to negligent cases. The trial judge accurately applied that rule in this case, and the 6th District Court of Appeal clearly stated what the rule is. It did not plow any new ground in its decision below. It simply looked at the cases in which this court has stated and pruned its decision, such as the case of Kirksey, such as the case of Slocum, such as LaPorte, such as Scott 2, and the underlying district courts of appeal cases where they clearly state that the impact rule does not apply to intentional torts. It just overtly stated that in this case, firmly consistent with the cases that this court has had. Now, if the court, and for those reasons, we would request that this court answer that first certified question. Is the impact rule an exclusion, or excuse me, is intentional torts an exclusion to the impact rule? We would answer that question in the affirmative in this case. Now, if the court didn't want to go that far and rule, we would argue, as the 6th District Court of Appeal found in this case, that tortious interference with an at-will contract or an advantageous business relationship is an exception to the impact rule under the freestanding tort exception that this court recognized in Cush. And a freestanding tort, by definition, is one that has an independent basis of liability, and that the damages are distinct from mental anguish or parasitic. The mental anguish damages are parasitic. That's the scenario that you have in this case. That's the rule that the District Court of Appeal applied in this case, well within this court's precedent. We have an independent basis of liability in this case, the intentional tort of tortious interference with an advantageous business relationship or at-will contract. And the damages of mental anguish are in addition to the economic damages that were awarded in this case. So I would request that this court answer that second certified question, that tortious interference with an advantageous business relationship is an exception. Intentional torts are exclusions, as identified by this court in a Rowell versus Holt decision at footnote 1 and recognized in the April decision from this court. And then finally, we would argue that if the court didn't want to rule that far and wanted to rule narrowly, that it could find malice in this case. And we would say there would be one of three rubrics the court could use, or three different rubrics. First, the court could hold, as the 6th District Court of Appeal did, that actual malice is present under the facts of this case.
Did the jury find that, though? Was that a jury finding?
We would argue, Your Honor, under...
Was the jury instructed on malice?
It was not in the instructions.
So it was not in the instruction. So how do we know that the jury concluded that there was malice? From what would we draw this assumption?
Sure. Under the 4th District Court of Appeals decision in Hercello, in cases of tortious interference cases, they concluded there that actual malice can be determined in one or two ways, either by proof of ill will or spite, or, in these types of cases, by improper means being utilized. That was an example.
And who's supposed to make that finding?
The jury.
Court in the first instance?
The jury can make that finding.
Okay.
And in fact,
the jury did not make that finding below. Right?
At the trial court and the jury made that finding, yes, Your Honor.
Okay.
The jury made the finding that what was at issue at trial, the judge ruled summary judgment that an intentional act had occurred, right? The intentional part of it. The issue then was, is it justified? And the issue then became, was it proper means used for the interference? The jury found no proper means for the interference. Our position is that improper means under the Hercello decision is a manner in which to find actual malice under that decision, one of the ways. And now we would also...
You're eating in your colleague's time. I don't know if you want to...
And I'll wrap it up, Your Honor. Therefore, we would request that you answer the first certified question in the affirmative, that intentional torts are exclusions to the impact rule. 2, that the tortious interference with an advantageous business relationship or at-will contract is a exception to the impact rule, and that actual malice is present in this case. Therefore, under the facts of this case, it is an exception. Therefore, we'd ask this court to affirm the 6th District Court of Appeals opinion in this case, and to the degree that is any conflict with the Reed decision, that you quash that decision. Thank you, Your Honor.
Thank you.
May it please the court, Kyle Mason on behalf of Amicus Florida Justice Association. Your Honors, the question before the court today is whether Florida should become a minority of one by being the first state to expand the impact rule to encompass intentional torts. I respectfully submit that the court should not do so because it's contrary to the vast weight of American jurisprudence on this issue and to the rationales that underlie the impact rule.
We're kind of already there. I mean, we're already in the minority in having an impact rule in general. Correct.
That is absolutely correct, Your Honor. But
so I guess what do you see us doing? Are we cabining what was kind of initial error, or do you see this as truly something distinguishable from as a matter of logic in the negligence context versus an intentional tort context?
So, Your Honor, I do think it is distinguishable between the negligence, and for several reasons, which the other courts that have addressed this issue have discussed. First, intentional torts serve the similar purpose as physical impacts, and in that it authenticates that a real legal injury has actually occurred. That's different from a negligence context. When you have a negligence without a physical impact, which happens all the time, every time we speed on the highway, that's negligence. There is a potential for some sort of unmoored emotional distress, but there's really no other cognizable legal interest at stake. So when you have an intentional tort, you know that the the plaintiff has suffered an actual injury because there has been an infringement on some legally cognizable injury, interest, whether that is, the right to an advantageous business relationship, or whether that's, the right to be free from insult.
Don't you have to concede if the focus is on the logic of the difficulty of proof, there's no difference. But it seems like the reason for the impact rule is it's not saying that emotional distress damages are not a real thing. I think it's just based on the idea that, in the negligence realm, the law is going to sort of err on the side of not subjecting the negligent party to such speculative damages. And I think it seems like the reason why you would distinguish the intentional torts is that even though you acknowledge that the proof problems are the same, that essentially when the party is kind of culpable in this different way, in this, intentional wrongdoing, it's like we're going to, in the negligence context, the claimant is the one who sort of bears the risk of the rule sort of being over-inclusive. And in the intentional tort context, you shift the possibility of getting it wrong onto the intentional wrongdoer. I mean, it seems like that would be the basis for the distinction. It can't really be, the difficulty, the speculativeness of the harm or whatever. That's kind of the same.
I would largely agree with that, Your Honor. It's definitely one of the reasons to distinguish this is moral culpability in intentional torts are just much higher. It's a moral wrongdoing.
What is the law? If you assume that this is a real, in reality, that it is a possible harm, and you're sort of taking it off the table or leaving it on the table, you could imagine that a reasonable sort of distinction for where you would leave it on the table is when someone did something intentionally wrong, and you would take it off the table when they were merely negligent. I mean,
that's exactly right, Your Honor. I completely agree. I would also add that in terms of just pure foreseeability, intentional torts, it's more foreseeable that there's going to be harms, potentially including even emotional and mental distress, just because when you intend to cause somebody harm, you tend to cause more harm than a negligence claim in just a similar context. So I would agree that there are policy reasons, rationales based on just the moral, the wrongdoing, however we want to phrase the distinction, and just foreseeability, and also that it serves intentional torts serve an authentication purpose, the same authentication purpose that physical impacts do.
Well, I don't think that's really. I mean, that to me is not. It doesn't matter. But I don't think that's not persuasive.
So can I ask you about next question? No.
I'd go with that.
One of the concerns I have is that we're being asked, because of the conflict, and I understand what was presented to the 6DCA, and they were kind of constrained. The conflict is presented as this very broad rule, but there seems to be this issue floating out there about whether this category of damages is available in this cause of action at all. Do you see any issue with kind of leaving that unaddressed? Is that going to create issues down the road if we've announced this rule that impact rule is not available or does not apply to intentional torts? But then there's still this question of whether emotional damages are available as a category of damages, depending on the cause of action.
So, Your Honor, and please feel free to correct me if I misunderstood the question, but I would believe that if we answer, say, the first certified question in the sense that the impact rule does not apply to intentional torts, then proving mental and emotional damages in intentional tort cases would be, as my colleague said, much the same as proving in a physical impact tort. You would present evidence. If the court wished to address the sufficiency of that might be an issue in another case. It was not. Yeah,
I'm not so much talking about sufficiency. I think it was the 4th DCA case that says you can't get emotional damages and intentional interference with the advantageous business relationship. Anyway, there's district court cases suggesting that this category of damages is not available.
That could be just a rule of law that's totally independent of the impact rule.
Right. And so my concern is that we announce this broad rule about applicability of impact rule to intentional torts, and then there's these ancillary issues in the cause of action that's presented in this case about whether that category of damages is even available.
Right.
Do you see that as a concern, or do you think the addressing one rule kind of takes care of the
I don't think it's a concern, Your Honor. but principally because if this court does have those ancillary concerns, it can simply state in its opinion that we're just simply deciding the scope of the impact rule, and that broadly speaking, it does not apply intentional torts and nothing else is raised, so we're going to affirm. If the court wants to limit its opinion in that matter, the court can do so. Whether as a matter of logic there can be emotional or mental damages in these claims for intentional interference with a business relationship or a contract, that might be best briefed in another case where it could be the focus of the briefing. So that's where I would draw the distinction. I don't think it would be a concern that would prevent the court from accurately stating the scope of the impact rule as it has been presented by the briefing and by the certified questions. With that, Your Honor, Your Honors, I would simply add just briefly that this exact issue has been addressed by the other state Supreme Courts directly. It was directly addressed by the Indiana Supreme Court, which is another impact rule state in Collison. It was directly addressed by the Georgia Supreme Court in a line of decisions, tracing all the way back to its Chapman decision, which this court relied on in 1893 when it adopted the impact rule. And that the law, American jurisprudence, Florida jurisprudence on this is just exceptionally clear. Impact rule does not apply to intentional torts. And for that reason, the court should affirm the judgment of the 6th District. And unless the court has any further questions for me,
Thank you.
May it please the court, I would simply address 2 points on rebuttal. First being that in writing its opinion, this court should address the freestanding tort doctrine. When the court used that terminology for the first time in Cush versus Lloyd in 1992, it didn't define that term. In the 6th DCA's majority opinion, it's the first time we see a definition for it. And I think Judge Smith, in his dissent, does a very good job pointing out that using that definition would lead to every tort falling within the definition. The second thing that I'd like to address is what my friend from the FJA, on behalf of the FJA, just submitted to the court, which was that the court could write its opinion essentially finding that the impact rule doesn't apply to any intentional torts, but then not address whether or not emotional distress damages are even recoverable in the first place with this cause of action. I submit that would be yet another case in a long line of cases involving the impact rule, creating more confusion. The litigants argued below over LRX and whether emotional distress damages were recoverable in these cases. And just like Texas, if we want to look to other states, parties shouldn't be able to recover emotional distress because they were really upset that their contract was breached, or they were really upset that their business case fell through. This court should absolutely address that issue in its opinion of whether emotional distress damages are even recoverable in these types of cases.
But that's partly kind of a prudential thing for the court. I mean, there's the certified question about the impact rule and intentional torts, and then there's this particular thing. And I don't know that it would, quote unquote, create confusion. It would just kind of leave for another day this sort of more discrete issue about this particular cause of action and what damages could or couldn't be recovered. And the arguments would just, in that later case, they would just be not about the impact rule anymore. There would have to be some other reason why the party that didn't want them to be available would have to persuade whoever the decider is that they wouldn't be.
Certainly it would depend on how the opinion's crafted by this court, but I would actually disagree with Your Honor on that point. If an opinion comes out and it only addresses those certified questions and says, does the impact rule apply to intentional torts? And if so, does the impact rule apply to the cause of action for tortious interference with an advantageous business relationship? And this court only answers those questions and says, no, it doesn't apply to intentional torts. No, it doesn't apply to this cause of action. Then what we're left with is an opinion that lawyers and judges around the state will look to and say, well, there was that cause of action that I'm dealing with in my case, and the court upheld a jury verdict for emotional distress damages. What am I left to do at that point?
Well, but of course, the questions we answer are up to us.
Absolutely.
And we don't have to answer the questions that the district court has certified. We could answer just the first question. We could just answer the question about whether the impact rule applies to intentional torts, and if we decided it adverse to you, then that would be that, and then these other things would be for another day, right?
I agree, but I still
I know you
would
wouldn't like
submit.
that.
I still would submit we'd have the same problem that we had in this case, where the trial judge, the reason the trial judge ruled the way he did, is he looked and he saw the Abril opinion where the court made the statement that the impact rule does not apply to any intentional torts. And that issue is very well set forth in the briefing and the opinion from the 6th DCA, where they point out that the support for that statement by the court doesn't exist. When they go to the Roel versus Holt case, in the footnote 1 of that opinion, it says that the rule doesn't apply to certain recognized intentional torts in a very narrow subset of cases. Justice Labarga, did you look like you were about to ask a question?
You're just making me think.
Could I ask you to do one thing? I was making a note and I didn't quite catch it all. When you were answering Justice Francis's question about I think it was her question about what the opinion would look like. Yes. Can you answer that one more time for me?
Absolutely. So the way that we would suggest the opinion be written is start by setting forth the certified questions, and we would do so by using the first certified question from the majority opinion in the Reese
and
case.
You would say the victim
and then the second certified question from Judge Smith's dissent, and we would answer in the affirmative that it applies to intentional tort cases, and in the affirmative that the impact rule applies to the tortious interference.
So what you said about
advantageous.
Unless there's substantial proof that.
Well, what I was suggesting, Your Honor, and very good, after answering these questions in the analysis that the court sets forth, I would suggest that the principles that should be addressed in this opinion, one, are the proof issue that the court addressed in Saunders, and two, this freestanding tort issue that came up in Cush versus Lloyd. And for those reasons, we ask that the court reverse the trial court's denial of the directed verdict motions that were filed by Synergy. And thank you, court, for the time.
Thank you. We'll be in recess for 10 minutes.